Hello and welcome to the Kenneth Vercammen Law Office Legal Podcast, the NJ Laws Tube. In this edition, we discuss wills and estate planning for teachers. Teachers work on average more than 80,000 hours in a lifetime. In spite of all our resources and assets we earn during our lifetime, the vast majority of Americans don't take the time to properly have a will prepared, or even appoint guardians for their children. In the absence of a will or other legal arrangement to distribute property at death, the state may step in to administer the estate and decide who gets custody of your children and handle their money. The process is called intestacy. This can create lengthy delays. Now, where there's no will in New Jersey, state law says who receives the assets, or if there's no immediate family, they could go to the government themselves. Now, not too many people want to have the government getting their assets. If there's no will, or the will is not prepared properly, or is not admissible to probate, number one, people you dislike or ignore you may get your assets. 2, state law determines who gets your assets, not you. 3, there's additional expenses that probably will be incurred, such as a surety bond, additional other court costs, and legal fees. You lose the opportunity, as 4, the opportunity to reduce estate taxes, state inheritance taxes, or federal state taxes. So you should have a will, so then you sit down with the attorney and go over what needs to be done. If there's no will, a judge determines who gets custody of children. So a greedy brother or crazy mother-in-law could ask the court for custody of children. And if you have no spouse or close relatives, the state may take your property. 7, the procedure to distribute assets becomes more complicated. And 8, it'll probably cause fights amongst the family. So when loved ones are grieving and dealing with assets, they shouldn't be overwhelmed with financial concerns and what to do. A will must not only be prepared within the legal requirements of state statutes, but also prepared so it leaves no questions regarding your instructions. So think, who don't you want to receive your assets? Without a will, those people could receive your assets and request custody of children. Other things regarding who's going to be the guardian or trustee, who is not the best choice to raise your children or safeguard your children's money for college or grandchildren. Do you want children or grandchildren to get money when they turn 18? Probably not, because they won't invest the money wisely. They'll go to Seaside and play video games. Now, life insurance. Sometimes it's not wise to leave children as a beneficiary of life insurance, or beneficiary of your pension if the children are under the age of 21. That's important for teachers. You can make your estate the beneficiary of life insurance and pension, and then direct in your will that the money be used to provide support and college expense for children or grandchildren. For example, the will could provide that a portion of any monies to be held and not distributed to someone under the age of 21. But it can be used for health and education, maintenance, support of that child or grandchildren. Sometimes people don't want to leave money outright to, spouse or other family members. So, what are some of the clauses that should be in the will? 1, debts and taxes be paid. 2, specific bequests. Is there any specific asset to go to one person? There could be, an amount of money to a particular relative or charity. 3, disposition to spouse. Sometimes the clause says no disposition to spouse. It could be second marriage, or the spouse could be in a care facility. 4, disposition of remainder. 5, sometimes creation of trust for the spouse. 6, sometimes creation of trust for children if the children are under the age of 21 or even 25. 7, other beneficiaries under 21. Then 8, who are going to be the executors? The executor is the person who carries out your wishes in the will. 9, who would be the trustees if a trust is set up. 10, who are the guardians? 11, you want to have a clause that says no bond is required, and your attorney will explain that to you at the interview. Even if you have an existing will, there are many events that occur which may necessitate changes in your will. Some of these are marriage, birth, death, divorce or separation affecting either you or anyone named in your will. 2, significant changes in the total assets that you have, because there's different levels of taxation. 3, change in your domicile, where you live. A will that's prepared in New Jersey is valid in another state, but that doesn't mean it's best for that person. Also, some reasons why there could be a need for a change: the death of the beneficiary, death of his executor or trustee. Let's see, and most importantly, changes in who you like and who you want to get your assets. Sometimes clients ask, may I change my current will? Yes, a will can be modified or completely changed as long as someone is mentally competent. Let's see, now, what are some of the things that you should do? Well, meet with the attorney, have your will prepared. Let's see, have the will prepared, distribute assets to the people you care most about. Let's see, 2, have a power of attorney prepared. Let's see, for someone to handle your finances if you become disabled. 3, have a power of attorney prepared. 4, make sure that on assets that you have, such as your teacher's pension, that it specifically sets forth who you want it to get. And then lastly, contact human resources to make sure that if it's your spouse's company, find out who the beneficiary is. Let's see. Now, in New Jersey, you want to make sure your attorney prepares what's called a self-proving will, so no bond is required. And for other information, visit the website njlaws.com. That's njlaws.com. That provides other information on wills, powers of attorney, other documents. Or contact the law office of Kenneth Vercammen in Edison, 732-572-0500. Thank you and good luck.